Welcome to Leka Eto Speak YouTube channel. Thanks for watching. Please don't forget to subscribe.
Lovers all over the world, welcome to our YouTube channel. Gẹ́gẹ́ bí ẹ ti mọ̀ pé update lọ́lọ́kan ìjọ̀kan náà la máa mú wá fún yín. Update eléyìí tá a mú wá fún yín, update nípa Segun Olowokere àti ìkejì ẹ̀ tí àwọn òbí ẹ̀ tí wọ́n sunkún ní orí fídíò kan tó go viral wípé ọmọ àwọn jí adìẹ gbé ni wọ́n ṣe dá lẹ́jọ́, pé ni wọ́n ṣe rán ní ẹ̀wọ̀n, pé ni wọ́n ṣe dá ẹjọ́ kú fún. So ẹ gbọ́ nǹkan tí ó ṣẹlẹ̀ nípa ẹjọ́ tí wọ́n dá fún Segun Olowokere. Full details ènìyàn máa gbọ́ lẹ́nu àwọn tí wọ́n wà ní system náà, tí wọ́n wà ní agbọnnu ètò ìṣèjọba ìpínlẹ̀ Ọ̀ṣun lọ́wọ́lọ́wọ́ tá a wà yìí. So ẹ máa gbọ́ àlàyé lẹ́kùnrẹ́rẹ́ nípa nǹkan tí ó ṣẹlẹ̀ tí wọ́n fi ti Segun Olowokere mọ́lé tó fi di pé wọ́n dájọ́ fún tó fi di èrò ẹ̀wọ̀n. Ẹ máa gbọ́ full details because wọ́n ní kí á wádìí gbogbo dájú kí á tó di eléyìí tó ń jẹ́ òtítọ́ mú because àwọn èèyàn wọ́n ń gbérú mọ́ lóríṣiríṣi and then èmi máa ń like wípé kéèyàn ṣe clarification, kéèyàn ṣe confirmation nǹkan tó bá ń ṣẹlẹ̀, kéèyàn mọ́kàn déédéé máa sọ ọ̀rọ̀. So ìdí nìyẹn tá a ṣe mú program yìí wá, tá a ṣe share lórí ìkànnì wa lórí YouTube channel wa. So ẹ̀yin tẹ́ bá ṣe ń darapọ̀ mọ́ channel yìí ẹ bá wa subscribe, ẹ likes, ẹ comment. So full details ẹ̀kúnrẹ́rẹ́ nípa nǹkan tó ṣẹlẹ̀.
It's a pleasure to have you. The last time I spoke with you concerning Segun Olowokere
ní Rave FM àkíwọn. So ẹ gbọ́ ló ṣẹlẹ̀ ẹ̀kúnrẹ́rẹ́ nípa Olowokere àti àwọn òbí àti àwọn tí wọ́n yọjọ́ tí wọ́n lé. So gbogbo àwọn wà tán wù tó fi di pé wọ́n di èrò ilé ẹjọ́ pátápátá, gbogbo ẹ̀ lẹ́ máa gbọ́ lẹ́kùnrẹ́rẹ́. Ẹ ṣé gan ni.
What's the latest concerning this matter?
As far as the matter of Olowokere is concerned, the latest now is that the investigation directed by His Excellency Governor Ademola Adeleke has been carried out by the Honorable Attorney General of the state, Barrister Wole Jimmy Bada, and other relevant officials at the Ministry of Justice. So as I appear here this morning, I can speak.
Great.
I can make some categorical statements as regards the case. But before I delve into that, I would like to clear air on something first, which pertains to the investigation directed by the governor. About a week ago, there was a press release by Mr. Mutalubi Ojo, former Attorney General of Oyo State. In the release, he cautioned His Excellency against what he viewed as usurpation of the power of the judiciary as regards the directive given by His Excellency to the Attorney General to investigate the claims of Olowokere's parents. The truth of the matter is that the investigation directed by His Excellency was not that the Attorney General should review the judgment of the court. The investigation directed by the governor was that the Attorney General should try to gather facts to verify, to confirm the veracity of the claims made by Olowokere's parents in the video. If you look at anybody who has watched the video will notice that the information given as regards the case was not detailed. So there was no way somebody will watch the video and will begin to make a categorical statement unless somebody that was directly involved in the case. So the charge number was not mentioned in the video. In fact, the name of the convict was not mentioned properly. So the governor directed the Minister of Justice, the Attorney General, to investigate, that is, to do a kind of fact-finding about the case, so that to be seized of the facts. You will recall that when the man, or let me call him man, was arrested in 2010, it was not His Excellency that was in power. Yes. In 2014, when he was convicted, it was not this administration that was in power. So the Attorney General had to do some findings before he could verify the claims. So I'm using this opportunity to clear air on what Mr. Mutalubi said that probably the directive given by His Excellency to the Attorney General was to review the judgment. We know the Attorney General is a lawyer. I'm a lawyer. We know it is outside the purview of the power of His Excellency to direct a review of the judgment of the court. It is only a higher court
that can do that.
That can do that. We know that. But the impression given in the press release is what I'm correcting now. The impression is wrong. It was a total misconstruction of the directive given by His Excellency. His Excellency never directed the Attorney General to investigate the judge or review the judgment. He only directed the Attorney General to make its findings to confirm the veracity of the claims made by Segun Olowokere's parents. And that's having been said.
Okay, maybe I should add this because I was going to ask you anyway.
Yes.
That what would be your reaction to the opposition party that accused Governor Adeleke of grandstanding, and trying to use Olowokere's case to score a political point?
No, you see, we are in a democracy. Criticism is good. But some people have turned themselves into armchair critics. No matter how wonderful the performance of an administration is, some people will just gather themselves in the name of doing opposition. They will find one or two things to rubbish what the administration is doing. I cannot understand how a reasonable parent will watch that video, that heart-rending video, heartbreaking video, and it will not be moved. His Excellency, when his attention was drawn to the video, he watched it. As a parent, he was overwhelmed, he was consumed with compassion for the parents. It was not that His Excellency believed the stories, concluded that the stories narrated by the parents were true, but some circumstances stated in the video would normally draw the pity of a parent, and that was exactly what happened in the case. And it was not a case of His Excellency where his grandstanding. Is what the parent said in the video will move an average parent. And you will remember, His Excellency did not just say, okay, Segun Olowokere is pardoned. His Excellency said, directed the Attorney General to investigate the facts and initiate the process of granting him a pardon. I want us to understand one thing here. Regardless of the crime, the actual crime committed by Segun Olowokere, by the power, discretionary power conferred on His Excellency by Section 212 of the Constitution of the Federal Republic of Nigeria as amended, His Excellency reserves the power to grant a pardon to any convict, whether convicted of armed robbery, whether convicted of stealing, whether convicted regardless of the gravity of the crime. That provision of the Constitution confers that power on His Excellency to grant any convict prerogative of mercy.
So the governor have not stepped out of line.
The governor, by directing that the process of granting him pardons to be initiated, the governor has never done what is not within his power. It's lawful. It's very lawful. And considering the circumstances of the case, the parents narrated that's the only child they have. While in prison, he enrolled in one course, he did this, he did this. Yes, there are many applications before His Excellency, from lawyers, from other parents, appealing to His Excellency to exercise his constitutional power to grant pardon in their favor. But it is not granted as a matter of course. It is not every convict that applies to His Excellency. Some factors are considered, like some circumstances. And what has His Excellency done as a parent? And we all know him for compassion. Yes, His Excellency is a very compassionate being. He's a very compassionate soul. And no compassionate soul will listen to that video without being moved. So His Excellency knows he has that power and he can grant it. And he directed the Attorney General to initiate the process. And even let me tell you, before the incident, you know, for the past 2 months now, the Minister of Justice has been on the process of granting pardon to some people. You know, there's an advisory council that recommends to His Excellency. The council has been working for the past 2 months. They have been working. The correctional service has forwarded some names. You know, it is the warders that stay with these people. They are the ones that can say how their behavior has been. Have they shown any signs of remorse after being convicted? What has been their behavior? So from that, the correctional service normally recommends some people. Many people did not know this. Even His Excellency did not know
that this inmate has shown remorse. He has shown some level
of
behavioral change.
Last 2 months we started the process. The advisory council started looking at the recommendation from the prison service. When we launched investigation into the case of Olowokere, we discovered the letter, the list prepared by the correctional service and sent to the advisory council in November. Olowokere's name is number 13 on the list.
Oh.
But you know, in that video, the name was not even mentioned. The charge number was not mentioned. Immediately His Excellency watched the video, immediately the Attorney General watched the video, it could not be concluded that his name was there. But when we started the investigation, we got to know, we invited the parents, we invited the state council who handled the matter, the prosecution in 2013-14. They brought their file. We look at the name, we look at the charge. When we went through the list from the prison, from the correctional service, we found that his name is on number 13.
So Segun Olowokere was
already
listed,
recommended by by the correctional service. Amazing. For pardon of his Excellency. So you can see now. You can see now. Apart from that, we extended our investigation to the court, to the case file in the court, to know what how the proceedings went during the trial. It was discovered, even in the judgment convicting and sentencing Segun Olowokere, His Lordship, who gave the judgment, who sentenced him, recommended that His Excellency should, if he so places, commute the death penalty to 10 years jail term, 10 years imprisonment.
That's true.
And you will notice the parent. I'm of the opinion that it was that recommendation in the judgment that moved the parent to go to the media, to go and make that video.
That it's been 10 years.
It's been 10 years. Probably they were thinking they didn't have any means of meeting with the governor, reaching out to His Excellency. They decided to go and make that video. That's my belief. So the recommendation given by the judge, by His Lordship, who delivered the judgment, the recommendation from the prison, taken together, I think qualify Segun Olowokere for the mercy of His Excellency. However, His Excellency deciding to grant pardon to Segun Olowokere does not mean His Excellency believed that all the stories narrated by the parents are true. And if His Excellency believed all the stories narrated were true, he will not direct the Attorney General to find out, to confirm the veracity of their claims. But His Excellency directed that the process of granting him prerogative of mercy, pardon, should be initiated, because regardless of what might have led to his conviction and sentencing to death, His Excellency reserves that constitutional power to grant pardon to any convict. So nobody can challenge him in the exercise of that dictionary power. His Excellency has not stepped outside the boundaries of his power to say, okay, Segun Olowokere, I grant you pardon. It's not only Segun Olowokere. I've told you about the list sent by the prison in July, in October, or in November, before the video came out. It was not only Segun that was recommended from the prison service. I told you now that Segun is number 13 on the list. So when a governor decides to exercise the discretionary power to grant pardon, the advisory councils looks at the recommendation from the correctional service. Okay. From there, they look at the circumstances before they will now recommend to His Excellency. Okay, we have found these people to we have found them deserving or deserved. We have found them to be worthy of grant of pardon, considering certain circumstances surrounding them. Like the advisory council now, in looking at cases of people that will be pardoned or not, one of the factors considered, I must tell you, is they want to see the armed, if it is a capital offense, did it lead to loss of life? Yes, they will look into that, because they are equally conscious of the effects of releasing some people back into society. They will look at their judgment. What led to his conviction? Okay, if it was armed robbery case, was any life lost in the incident? What were the circumstances? How remorseful has the convict been? How long has he been in prison? We have a case of a 95-year-old man on death row. 95-year-old. He is one of those that the correctional service has recommended for the pardon of His Excellency. So if the APC does not, they couldn't find any area to criticize His Excellency, would they say, okay, the governor is trying to release, if that person is recommended for the mercy of His Excellency, Excellency releases him, would they say His Excellency has released a 95-year-old man so that His Excellency can use him for election or what? Is that not reasonable? These are the factors considered. Yes, the prison service has recommended people who are 85 years above and they are on death row, believing that when these people are released into society, the likelihood of them going back to crime is very low. So those are the factors considered. Some people are some people have acquired skills while in prison. So the prison service considers that, believing the skills they've acquired while in prison will enable them to be an asset when released into society.
It's a correctional center anyway.
Yes. Are you getting it now? So His Excellency has never released anybody without due consideration.
So he has that constitutional
power. He has that constitutional power. The president has it. The governor has it. And it is the constitution that confers that power on them.
Amazing. Barrister, we need to hold on at this point. Karim is a legal practitioner and special advisor on legal matters to Osun State Governor Ademola Adeleke. All right. Barrister, you've spoken to, or you've clarified the air, as regards
the power of His
Excellency in
grant pardon.
Grant pardon.
And he has decided to grant that pardon.
Amazing. All right. Now, for Femi Falana, who is saying that Morakinyo Sunday also should benefit, in this prerogative of mercy. Is he qualified for it?
You mean Segun?
Femi Falana is saying that since Segun Olowokere was sentenced alongside Morakinyo, and that the governor, had deemed it fit that Segun Olowokere should be pardoned. Wow. And Morakinyo Sunday should also be considered.
Wow, that's very good. That's a very good area. When we started the investigation, in the video, the parent did not mention that there was another convict. It was when we started our investigation, the Attorney General, we called for the file. We discovered actually it was two of them that were convicted and sentenced to death by hanging. We looked for the parents of the second convict, Morakinyo. They came to. We asked them, how old is your? They said, as of 2010, he was 18.
Oh.
Morakinyo was 18 as at 2010. According to the family, as at 2010, Morakinyo was 18. And that was the exact age contained in the extrajudicial statement written by Morakinyo himself, which was tendered before the court. That's one. So His Excellency now directed that it will not be just, it will not be fair, since the judge that gave the judgment recommended both of them for pardon. It will not be fair to single out Segun Olowokere, probably because of the video made by the parent. No. His Excellency directed the Attorney General to look into how two of them could be accommodated in the pardon. And as I speak with you, efforts are in top gear to ensure two of them benefit from the prerogative of mercy of His Excellency.
Amazing.
The only thing we have done, we invited the parents. You know, we want to be sure that he has somebody to receive him, because it goes beyond just releasing somebody in society. We must be sure there are people to take good care of him, so that they will continue that process of rehabilitation. We invited the parents and they were happy, and they gave us their word that they would take very good. They were very happy. They were very happy, and they gave us their word that they will continue the rehabilitation.
But it was said that his insanity now, happened while he was in custody, that he was brutalized, and that he because I read a report where Segun Olowokere, granted an interview and said that Morakinyo was brutalized, and that he bled for several days while in custody and all of that. Did your findings, how to verify some of these? Our
findings, with respect, do not reveal that fact.
Okay.
In fact, in the judgment, His Lordship made an allusion to that issue of mental health of Morakinyo. But remember, I said the two of them were defended by a legal practitioner. In that case, His Lordship said in the judgment that when they were doing arraignment, as at the time they were being arraigned before the court in 2013, nothing was wrong with Morakinyo. The arraignment was proper. No any claim of insanity. He was proper before the court. He spoke before the court. He was normal. But when trial started, the claim of insanity was raised. And in the judgment, His Lordship says there is under section 27 of the Criminal Code, there is presumption of sanity for everybody. Anybody brought before the court, the law presumes that you are sane. Now, the burden of proving that you are not sane rests on you. Now, police, when you are presented before the court as a defendant, the law, section 27 of the Criminal Code, presumes you to be sane. Now, if there's a contrary fact, you want to rebut that presumption. The burden of rebutting that presumption rests on you, defendant, before the court. The court is now saying in that judgment that the learned counsel who defended the convicts was the one that informed the court during the trial that the second defendant had developed mental issues while in prison. But nothing said, no any evidence led in support of that. The mental issue was developed while in prison. The prison service was not called as a witness to buttress that claim. Are you getting it? During the arraignment, Morakinyo was okay, was normal. The arraignment was done properly. He spoke. No any issue of insanity was raised. But when trial began, it was the lawyer that raised it. The court is now saying the judgment that it goes beyond the lawyer just claiming that somebody has developed. It must be supported with evidence before the court. The prison service, where is said to have developmental issues, as a clinic or a medical facility, no report was tendered to that effect. No witness from the correctional service was called to buttress the claim before the court. So, in the judgment, the court found that the presumption of sanity for Olowokere had not been rebutted by the defense.
It was the reason Justice Falola did not admit that.
He was insane. No evidence. Judges give judgment based on the evidence adduced before the court. Assuming it's not just okay because the lawyer raised it, yes, it's insane. The prosecution too could have leveled another allegation against his lordship. That for how will you be convinced that somebody, the presumption of sanity has been reported without any evidence led in that regard, without any report, without any medical report.
Thank you, sir. Quickly, let's look. Let's take beam some searchlight into your findings as regards Segun Olowokere. There were several stories as regards his arraignment, the allegations, the sentencing, and all of that.
We did the stories.
So I had to look for as many stories I could lay my hands on, just to understand this case.
Well,
was it true that he wasn't even at the scene of the crime? He was robbed. It was just two of those that were, arrested that mentioned his name, and that those that were arrested were actually released. And, it was said that they jumped bail without evidence.
Well, let me start by saying that I was not directly involved in the case. His Excellency was not directly involved in the case. Whatever we are saying about the case now is based on our findings from the case file, from the proceedings of the courts. And before I begin to go into that, I want members of the public to know one thing. I'm a legal practitioner. There is presumption of validity in the judgment of any court until that judgment is obtained or set aside by a higher court. As a lawyer, I cannot be faulting the judgment of His Lordship, because it is only a higher court that has that right, that power to fault it. So whatever we are saying now is based on what we have found in the case file. According to the case file and the proceedings before the court and the judgment, Segun Olowokere was not convicted or was not sentenced to death by hanging just because he stole fowl
And eggs.
And I want the whole world to take that as a fact. We owe Segun Olowokere's family justice. But justice is not a one-way thing. The court that delivered the judgment equally deserves justice for members of the public in our assessment of the saga, of the whole situation. A judge rules, gives his judgment based on the fact presented before it. A court gives its ruling based on the evidence adduced, based on the fact presented before it. The charge presented before His Lordship against Olowokere and Olowokere was that they conspired to carry out armed robbery about on 3 or 4 occasions. The incident of stealing of fowl was what actually exposed the earlier operations. The court found them to have been involved in. When the fowl was stolen, they arrested. Yes, it is true. They did not arrest Segun Olowokere and Morakinyo at the scene of the crime. But the people were arrested, while giving the extrajudicial statement, made mention of other operations they carried out before the incident of fowl stealing. They now mentioned members of their gang. They were the one that revealed that Segun Olowokere was their gang leader. They specifically mentioned that they gathered at Segun Olowokere's house and moved from there at midnight to rob one Elijah Umani. So when police heard that, police looked for Segun Olowokere and Morakinyo, picked them up at their dad's shop. You can confirm it now that truly Segun was not arrested at the scene of the crime. From what we have found in the case file, Segun and Morakinyo were not arrested at the scene of the crime, but they were mentioned and police investigated the claims. Though it is known in law that what a co-accused says about another does not carry force. If two of us are accused of a crime and I'm now giving the police information about you, you did this, you did that, what I'm saying about you may not carry force unless there are other pieces of evidence to corroborate the involvement of the other person. But when Olowokere now wrote statement, police arrested Olowokere, Morakinyo, they now confessed. Two of them, they confessed that truly they gathered at Segun Olowokere's house on the particular day when it was 12 midnight. They set out to the house of one Elijah Iyabo Umuani to rob her of her money, while armed with cutlasses. They went there. Though Segun Olowokere wrote in his statement that he was part of them, but he was not armed. He was not one of those who were armed with cutlasses. That he mentioned some names as people that were actually carrying cutlasses among them, but they went there together. He equally maintained in his extrajudicial statement that he did not enter the fence. He stayed behind the fence when they entered Elijah's house. But as they were trying to rob the Elijah, neighbors, Elijah shouted. The neighbors rushed in. That was how they left the place. But Segun Olowokere confessed in his statement that he was part of the gang, that they went to rob that Elijah. Then,
could there have been a possibility that he was coerced to make that statement?
Yes, I was not there. It's a possibility. But there is one thing in the law. Whenever anybody is charged with a capital offense, say robbery, armed robbery, murder, treasonable felony, the court will not proceed hearing the case without a legal practitioner representing the accused person. Are you getting the logic? Even when the accused person pleads guilty to the charge before the court, the practice, the procedure is that the court will write a plea of non-guilty for him. The court will want to listen to the prosecution to prove their case against him, because the law is mindful of the consequences of the person being found guilty of a capital offense. So in that case, Olowokere and Morakinyo were represented by a legal practitioner who defended them, and the judge states in the judgment that the conventional statement of Segun Olowokere, the lawyer who represented them, did not object to the admissibility of the conventional statements. The law has a procedure for the defense to challenge the tendering, the admissibility of purported conventional statement. The law has a procedure for it. If the police has forced you, coerced you into writing an extrajudicial statement, indicting yourself, the law has a procedure for you during trial to challenge, to raise objection that this statement was not made by me. I was coerced to make this statement. But the judge is saying in his judgment that no such objection from the counsel that represented them. Then it is outside the duty of the judge to himself raise objection.
To assume or presume?
To assume or to raise objection to the document, the extrajudicial statement presented by the prosecution as evidence of the guilt of the defendant before the court. So there are some people are saying it now. It could have happened that probably the police coerced them into making the statement. The court has found them guilty. It is none of my business to join them in saying that. I'm bound to hold that the judgment remains valid until the higher court sets it aside. And I can find from the judgment that those things, no opposition, no objection from the defense. How do we blame the judge for that?
But I quickly want to ask you, before I open up the phone lines, that you invited the parents to come.
Yes.
Can you say they were truthful in all they have said, or was it that they just raised emotions by that interview?
My conviction now is that the claims of Olowokere's parents in the video are a combination of truth, half-truths, and outright falsehoods. Yes, I can tell you categorically that from my personal findings from the parents, contrary to the opinion that as of 2010 they were arrested, they were minors, they were 17 years old, 16 years old. The parents themselves confirmed to me, yes, confirmed to me that Morakiyo was 18 years as of 2010 when he was arrested. Morakiyo's parents confirmed to me. Segun Olowokere's parents confessed to me that he was born in 1992. 1992 to 2010, that was 18 years. So when I'm telling you that their claims in the viral video are a combination of truth. I mentioned truth because they mentioned one thing in their video. They said Segun is their only child. We have found that to be true. So I cannot categorize all they said as falsehoods. So it's a combination of half-truths. As regards the age, it was when we did the investigation we discovered that Olowokere's father, who was in the video, was DW2 in the case.
What does that mean?
He testified in favor of his child during the proceedings. He testified. He was called as a witness, as a witness, DW2 in that case. So I will not believe that he does not really know what happened in the case. Then, knowing, I spoke with the lawyer who represented them in as part of our findings. I spoke with the lawyer to confirm truly that were they actually represented during the trial, and the lawyer confirmed that he was the one that stood for them throughout the proceeding, throughout the trial.
So as against the opinion of the public, they were sentenced not as minors.
Not as minors. No, let me present it like this.
Okay.
They were presented before the court not as minors.
Amazing.
But as adults.
As adults. Okay. 0806. Adults, please.
Please, let me say something.
All right.
I want to correct an impression. The governor has never made any attempt to review the judgment. Grant of prerogative of mercy does not amount to review of the judgment of the court. The court, given the judgment, has done justice. So it's a judge's discretion of the governor. So say, okay, you have been found guilty, you have been convicted, you have been sentenced to death. I'm pardoning you. Exercise my power, conferred on me by the constitution. And I'm telling the whole world now that His Excellency remains committed to granting pardon to both of them. Till now, the governor has not reneged on his move to grant them pardon because the governor believes he has the power. regardless of what happened. Now, taking together the recommendation from the judge to the governor that governors should pardon them, the recommendation from the prison service, even without having learned that, His Excellency was moved that it's a parent, it's a compassionate person that have the power. Even if I will use it, there are some certain circumstances, regardless of the lies of the parents.
And if the circumstances are
the circumstances are favorable to them. And that's why the governor is committed to ensuring those two guys are pardoned.
All right. Thank you so much. I've been speaking with Mr. Nuruddin Karim, legal practitioner, special advisor on legal matters to Governor Ademola Adeleke. Thank you all for your commitment. I think these lays to rest, this matter. My name is Daniel Odeyemi. Merry Christmas to you.
Lovers all over the world, a lérò pé ẹ farabalẹ̀ wo fídíò láti iṣẹ́ bẹ̀rẹ̀ títí dé òpin. Tẹ́ ẹ bá farabalẹ̀ wo, ẹ jẹ́ ká mọ opinion ti yín, ẹ jẹ́ ká mọ ohun tó ṣẹlẹ̀, ẹ jẹ́ ká mọ ohun tí ẹ̀yin lérò, because àwọn èèyàn wọn condemn wípé ìjọba kíní kan igbá àwo, a mọ̀ wípé àwọn ìjọba wa lẹ́kọ̀ọ̀kan náà àwọn náà ní àṣìṣe tiwọn, bọ̀ àwọn èèyàn náà ẹ jẹ́ ká mọ òkodoro ọ̀rọ̀, ẹ jẹ́ ká mọ ohun tó kan lè ṣẹlẹ̀ kí a tó mọ sọ̀rọ̀, ká tó mọ wádìí gbogbo dájú. So ẹni tẹ́ bá ṣe ń darapọ̀ mọ́ channel wa, subscribe, like, comment, ẹ bá wa share. So we love you all. Thanks for watching.